that the people of Kenya did not intend to grant such jurisdiction to the Supreme Court. Had that been the intention, the Constitution would have expressly conferred this authority in its final form. The Supreme Court has itself acknowledged that its original jurisdiction as outlined in the Constitution is exhaustive. This implies that any attempt to expand its jurisdiction beyond what is expressly provided for would contradict the Constitution's intent. Again, we refer to the case of Machari and another versus Kenya Commercial Bank, in which the Supreme Court itself stated as such. Article 163 of the Constitution provides for the jurisdiction of the Supreme Court in exhaustive terms, though leaving room for Parliament to prescribe further appellate jurisdiction in terms of Article 163 3b2, which stipulates that the Supreme Court shall have appellate jurisdiction to hear and determine appeals from any other court or tribunal as prescribed by national legislation. The Supreme Court goes on to note that the Constitution also confers jurisdiction upon the Supreme Court to hear and determine an appeal from a judge who has been recommended for removal under Article 168(8). As far as we are aware, Parliament has yet to confer any further appellate jurisdiction upon the Supreme Court in terms of Article 163 3b Roman 2 above. Even with regard to the special jurisdiction previously conferred by Section 14 of the Supreme Court Act, which was repealed by Section 15 of Act number 26 of 2022, the Supreme Court was unequivocal in again affirming that this provision did not grant Parliament the authority to expand the court's jurisdiction beyond what is contemplated in the Constitution. The court expressed this position. Again, we go back to the case of Machari and another versus Kenya Commercial Bank and two others. It's important to read the text. The Supreme Court states as follows: what is the proper province of Article 163(9) of the Constitution? Does the article contemplate a situation where Parliament can confer further jurisdiction upon the Supreme Court? We hold that it doesn't. The act contemplated by Article 163(9) is operational in nature. Such an act was intended to augment the rules made by the Supreme Court for the purpose of regulating the exercise of its jurisdiction. It is an act that must confine itself to the administrative.
Good evening, good morning, good afternoon from wherever you're watching us from around the world. Now, trending news in Kenya is that it seems that the journey of Mr. Gachagua, the throne, is getting more dense as the Court of Appeal has rules that the jurisdiction which was given, that the three-man bench to hear the case of Mr. Gachagua, has now been confirmed that it was within the law and it's provided within the Constitution. Now, going down to the Article 163, there is a clause there which talked about the same issue. Now, regarding to this provision, when you look at the jurisdiction, whether the Supreme Court or the Court of Appeal who has the right to now listen to this saga, then it has been expounded there. Now, disputes arising from the impeachment cases, especially of the president, are given around these clauses where they explain that the role or the full migration from the other former constitution. Now, people didn't grant the jurisdictions to the Supreme Court. Rather, they gave a provision on how these things are going to be done, and even the Supreme Court has acknowledged that the jurisdiction is within the law. Now, it seems that now the final case of Mr. Gachagua is going to happen in the coming days, or they won't really stop the swearing in of Mr. Kindiki, and it will be a very big blow to Gachagua in the coming days.